Hello friends, welcome to Massive Open Online course on state and local governance, machinery and processes. Today we are going to deliberate on the salient features of 73rd Constitutional Amendment Act 1992. In this regard, I wish to state that the Panchayati institutions across the country faced various kinds of roadblocks before the enactment of this amendment. In the formative years of the Panchayati institution, faced opposition from bureaucracy and primarily because of their lack of capacity, those were often hijacked and overpowered by affluent and powerful sections of the community. It was against this background that Ashok Mehta Committee, appointed in 1978, categorized the post-1959 period in three phases, which are ascendancy 1959 to 64, second stagnation 1965 to 69, and decline 1969 to 1977. How to reinforce and empower these institutions was one of the major challenges before the government at the time. It was felt that a democratic framework at the local level was indispensable for restoring the grassroots level democracy in local self-governance. This could be achieved by entrusting local affairs to democratic decentralization through elected representatives at the village level. In December 1992, Indian Parliament passed a path-breaking amendment to the Indian Constitution to revive and invigorate Panchayati Raj in the country. This amendment gave a constitutional mandate for democratically elected Panchayats at the village, district and intermediary levels in the whole of the country. The 73rd Constitutional Amendment Act of 1993, because of the reason it was assented on 24th April 1993. Otherwise, name is Constitutional Amendment Act 1992. This amendment ushered in a new era in the political and social transformation of India. The amendment made provisions for delegation of substantial power to villages, which remained till then under the control of both the central as well as state governments in various ways. This legislation in the form of constitutional amendment was a big ticket reform for the dilapidated Panchayati Raj institutions. Under this amendment, election to Panchayats were made mandatory every 5 years. Again, I am emphasizing this point. This is a very, very important one, and as a consequence of a constitutional amendment, that the election to the Panchayat Raj institution to be held every 5 years, that has been made mandatory, and that has solved the problem of their suspension and not to hold elections year after years, decade after decades. A provision was made in the amendment for 1/3 reservation of seat for the women, the scheduled castes and the scheduled tribes and other backward castes in proportion to their population. Here I would like to explain, particularly the students who have not observed the co-option system. Before the constitutional amendment, there was a co-option system for representing the women in the Panchayati Raj institutions by the elected representatives. Normally, the Sarpanch at the Gram Panchayat level, they used to nominate, and so is the case at the Panchayat Samiti or Jila Parishad level. They used to nominate the women of their favor, and that's why there was not real and meaningful representation of women or local self-government institutions. But this act has not only motivated the women to participate in the local self-governance, but it has brought such a good results that most of the state governments have not stopped themselves at 1/3 of reservation, rather they advanced it to the 50% of the seats are reserved for women in all classes of population, that is in the general category, scheduled castes, scheduled tribes or the backward categories. That's why this has been considered significant amendment for bringing social and political transformation at the village level or through the Panchayati Raj institutions. The 73rd Constitutional Amendment was considered a step forward, the real empowerment of the people. George Mathew, a scholar on Panchayat Raj institution in India, has rightly observed that to work independently, the local bodies need 4 F's, that is functions, funds, functionaries and freedom. Some people call it 3 F's and restricting themselves with the functions, finances and functionaries. They don't consider, they don't include the freedom, but George Mathew include the freedom also. Once these 4 F's are given to the local institution, local bodies will bring a paradigm shift in the socio-economic structure of the country. It is very important to state here that neither the central government nor state governments are willing to offer the 4 F's on a silver platter. Means they are reluctant to do so. The representatives have to demand for them, and that is where we are helping the local bodies. After discussing some of the important features of this Constitutional Amendment Act, let's discuss the legal framework with the passage of this Constitutional Amendment Act. Now, in the post-amendment era, Panchayats were recognized in the statute book as institution of self-government. Under the provision of this amendment, it became mandatory for each state to enact conformity acts and make the following provisions. The establishment of 3-tier panchayats with elected members at village, intermediate and district levels. The intermediate rung need not be constituted in state with a population fewer than 2 million. Direct elections to all seats in panchayat at all levels have also been made compulsory. As stated earlier also, 1/3 of seats reserved for women and marginalized communities, scheduled castes and scheduled tribes in all panchayats according to their population. These provisions also applies to the offices of chairperson of these institutions. A uniform 5-year term in all panchayats with election held within 6 months in cases of premature dissolution has also been made mandatory. The provision have been made to constitute a state election commission to supervise and organize free and fair election to panchayats at all levels. It has also made it mandatory to set up a state finance commission at a regular interval of 5 years to review and revise the financial position of panchayats or to provide them financial sustenance. The Constitutional Amendment Act and the statutory provisions made by the state legislature also provided for the establishment of district planning committees. It paved the way for the establishment of a Gram Sabha, that is, village assembly, in each village to exercise such powers and perform such functions at the village level as the state may provide by law, no doubt, as per the pattern provided there in the Constitutional Amendment Act. Now, at the cost of revision of some points, let's discuss the major provisions made under the 73rd Constitutional Amendment Act. The Amendment Act describes the Panchayats as an institution of self-government constituted under Article 243B for the rural areas, where the Panchayat area means territorial area of a Panchayat. There shall be constituted in every state Panchayats at the village, intermediate and district levels in accordance with the provision of this part. Notwithstanding anything in clause 1, Panchayats at the intermediate level may not be constituted in a state having a population not exceeding 20 lakhs. The composition of Panchayat. The legislature of a state may by law make provision with respect to the composition of Panchayats, provided that the ratio between the population of the territorial area of a Panchayat at any level and the number of seats in such Panchayat to be filled by election shall so far as practical be the same throughout the state. All the seats in Panchayats shall be filled by person chosen by direct elections from territorial constituency in the Panchayat area. And for this purpose, each Panchayat area shall be divided into territorial constituency in such a manner that the ratio between the population of each constituency and the number of seats allotted to it shall be so far as practical be the same throughout in the Panchayat area. The legislature of a state may by law provide that the chairperson of a Panchayat at the village level shall be elected in such manner as the legislature of a state may by law provides. And a Panchayat at the intermediate level of district level shall be elected by and from amongst the elected members thereof. Seats shall be reserved for the scheduled caste, the scheduled tribes in every Panchayat, and the number of seats so reserved shall bear as nearly as may be the same proportion of the total number of seats to be filled by direct election as the population of the scheduled caste in that Panchayat area or the scheduled tribes in that Panchayat area bears to the total population of that area, and each seat may be allotted by rotation to different constituency in a Panchayat. 1/3 of the total number of seats reserved under this clause shall be reserved for women belonging to the scheduled caste or, as the case may be, the scheduled tribe, not less than 1/3, including the number of seats reserved for women belonging to the scheduled caste and the scheduled tribes of the total number of seats to be filled by direct election in every Panchayat shall be reserved for women, and such seats may be allotted by rotation to different constituencies in a Panchayat. The offices of the chairperson in the Panchayats at the village or any other level shall be reserved for the scheduled caste, the scheduled tribes, and the women in such manner as the legislature of the state may by law provide, provided that the number of offices of chairpersons reserved for the scheduled caste and the scheduled tribes in the panchayats at each level in any state shall bear as nearly as may be the same proportions to the total number of such offices in the panchayats at each level as the population of the scheduled caste in the state or of the scheduled tribes in the state bears to the total population of the state. Further, not less than 1/3 of the total number of offices of chairperson in the panchayats at each level shall be reserved for women. Also, that the number of offices reserved under this clause shall be allotted by rotation to different panchayats at each level. In other words, in a very simple way, we can say that seats are reserved for scheduled caste and scheduled tribes in proportion to their strength in the total population of the panchayats. 1/3 of the seats are reserved for women, and that applies equally on the seats reserved for scheduled caste and scheduled tribes also. In those cases, in the cases of seats for scheduled caste and scheduled tribes, 1/3 of the seats reserved for them go to the women. Not only the seats which are reserved, even the offices of the chairpersons are also reserved. And the reservation is for scheduled caste, scheduled tribes, and 1/3 of those offices are for women. The provision of reservation, particularly in case of the offices, is by rotation. In case of other, that may be decided on the basis of the rotation and as per the provision made there in the state legislation in this regard. This kind of the reservation has provided a representation to all sections of society, including the women. The amendment further empowers the legislature of a state for making any provision for reservation of seats in panchayats or offices of the chairpersons in the panchayats at any level in favor of backward classes of citizens. This is again a very important aspect. The reservation for the backward sections of the population is not as per the strength in proportion to their population to the total population of that panchayat area. It is as per the will of the state legislature. So, the backward classes are also represented as on the seats as well as in the offices. The duration of the panchayats. Every panchayat, unless sooner dissolved under the law for the time being in force, shall continue for 5 years from the date appointed for the first meeting and no longer. An election to constitute a panchayat shall be completed before the expiry of its duration and before the expiration of a period of 6 months from the date of its dissolutions. However, in practice, if you say some of the states have adjusted the time period considering their assembly election, but they could not withhold it for a longer period as it was before the Amendment Act. Constitutional Amendment Act also provides for the powers, authority and responsibilities of panchayats subject to the provisions of this constitution. The legislature of a state may, by law, endow the Panchayats with such powers and authority as may be necessary to enable them to function as institution of self-government. And such law may contain provisions for the devolution of powers and responsibility upon Panchayats at the appropriate level, subject to such condition as may be specified therein, preparation of plan for economic development and social justice, the implementation of scheme for economic development and social justice as may be entrusted to them, including those in relation to the matters listed in the 11th schedule of the Constitution. Thus, there have been many provisions which have been considered instrumental in establishing the local self-government on a permanent basis, and it has attracted the people to participate in those institutions and become very popular one. Not only that one, the system or mechanisms have been developed, not constitutionally, rather politically, to have organic linkages among the various Panchayati Raj institutions as well as the linkages with the state government and the central government also. Keeping in with those facts, these provisions have ushered a new era in a new era of local self-governance. But before closing the discussion on this 73rd Constitutional Amendment Act, I would also like to share with you that the provision have been made to constitute a State Finance Commission and a State Election Commission as well as the District Planning Committee. The reference of these three institutions have already been made while discussing the important features of the Constitutional Amendment Act. These three topics, that is the State Finance Commission, State Election Commission and District Planning Committee, will be taken up as a separate talks in the subsequent weeks of the course. So, till then, I would like to thank all of you again and again and wish you a very, very happy learning.